it's a difficult judgment, arguably either way. Similarly, you may have passed the incidental test, or you may not. It depends. If the proportion of the consumer credit work that you carry out for that client is minimal in comparison to the entirety of the legal services work you do for that client, then you may have passed the test. Where do you draw the line? What if 10% of the work you do for that client is consumer credit activity? Is that complementary? Is it incidental? What if it's 25%? What if it's 40%? The simple truth is that nobody knows, and nobody can give you a definitive answer to that question. Debt collection work under the exempt professional firm regime. Up on your screen now you'll see another statutory instrument, the Financial Services and Markets Act regulated Amendment Activities Number 2 order. And this is the order which has introduced these changes, and if you want to have a good look at what debt collection and consumer credit activity means, this is the document that you'll need to look at, in particular Part 2 of that statutory instrument. So what to say about debt collection work? Well, first of all, litigation which arises from a consumer credit or a hire agreement is not affected by these changes. So litigation is not affected by these changes. Contentious work, post-issue work. The secondary legislation that I've just shown you, the statutory instrument, it brings consumer credit activities within the FCA regime, and it excludes consumer credit activities carried on by solicitors in the course of contentious business. Contentious business is defined in the usual way, Section 87(1) of the Solicitors Act. So this exemption has always existed. It was in Section 146 of the Consumer Credit Act, and it's been effectively brought across to the new regime by virtue of the statutory instrument we just looked at. But this exclusion, be clear in your minds, it's only available where proceedings have been issued, and it does not cover any pre-issue work. All pre-issue work, in terms of debt collection, must therefore pass both the incidental test and the complementary test. And I am going to set out those tests more clearly shortly. The position as I see it is that if you specialise in debt collecting, if that's your main activity, if that's the engine room of your practice, your main practice area, or your only practice area, then you will not be able to satisfy the incidental test, and you will need to be authorised by the Financial Conduct Authority. The EPF is not available to you. You fail the incidental test. Where it gets a bit more complicated is if debt collection is a significant part of what you do, and if not all of your debt collection work is post-issue. So you've got a good debt collection department, and that department deals with post and pre-issue work, then you're in a real grey area, and this is true of many firms. You will be carrying on regulated activities because of the pre-issue work that you do, and you'll only be able to rely on the exempt professional firm regime if those activities, those pre-issue debt collection activities, arise out of or are complementary to other professional services provided to that particular client. In reality, it's often not going to be the case. Often the pre-issue work that you do for that particular client will be the only thing that you do for that particular client, and therefore you will not be able to satisfy the complementary test. So you will not be able to carry out that work under the exempt professional firm regime. If you are doing that at the moment, you are breaching the general prohibition and committing a criminal offence, and you need either to stop doing that work or to apply for full FCA authorisation immediately, with all of the regulatory implications that that brings. The SRA, incidentally, and I do try to give credit to the SRA when it's due, the SRA has made representations both to HM Treasury and to the Financial Conduct Authority, arguing that the exclusion should be extended to cover pre-issue work as well as post-issue work. there has been no response from HM Treasury or FC or the Financial Conduct Authority, and there's no indication that the SRA are going to be listened to. But to the SRA's credit, the SRA did attempt to make that case. The last thing to note is that not all debt collection work actually involves you carrying out regulated consumer credit activity. So, it may be that some of this pre-issue work is not actually a regulated consumer credit activity. It's only when the debt collecting relates to a consumer credit agreement or a relevant Article 36H agreement as defined by the Financial Services and Markets Act 2000 Regulated Activities Order as amended. So do check that it is actually regulated activity that you're carrying out, otherwise this whole thing ceases to be an issue for you. If you do have to go for Financial Conduct Authority authorisation and regulation, what will it be like? Well, if you want to get a feel for what it would be like, I suggest that you have a look at the consultation document, which should now be on your screen. It's 191 pages of bureaucratic regulatory nonsense, and it'll give you a great flavour for where all of this is heading. How about the process of applying for authorisation? Applying for financial conduct authorisation is not something which I've historically been involved in. That may have to change. I hope not, but it may. From the research that I've taken out, that I've carried out so far, it seems to be that it's accepted in that industry that the average professional fees for getting advice and guidance through the authorisation process are in the region of £10,000 if you're fortunate. If you have a look at the web page, the authorisation page on the Financial Conduct Authority's website, which is on your screen now, you'll see various links and pages running. Well, there's over 500 pages of information for you to consider as part of filling in your initial form or forms. There are many of them. So applying for authorisation, I think, will be pretty horrendous. So therefore, you do need to ask the question very seriously: are we doing any consumer credit work? If we are doing it, do we want to continue doing it? If we're not doing it, are we certain that we can avoid it always, every day, forevermore? And you need, I'm afraid, to have a serious look at the regulated activities order, which again is on your screen, and you do need to go through in detail part 2 of that order and consider what it means for the various activities that you undertake in your various departments. So look through part 2 of the order, ask yourself, is the activity that I'm considering and that I'm concerned about, is it a specified activity? Does it have the benefit of any exemptions or of any other conditions specific to that type of activity? If you can answer those questions to your satisfaction, then ask whether it is being provided to a particular client in a way which is incidental to and complementary to, both tests, the professional services that you provide to that client. I keep referring to the incidental test and the complementary test, and I want to talk, I just want to clarify what exactly they mean. I apologise if there's a bit of repetition here. The Financial Conduct Authority considers that to satisfy the condition in section 327 of the Financial Services and Markets Act, then regulated activities, so this is the incidental test, regulated activities cannot be a major part of the practice of the firm. The FCA also considers the following factors to be relevant: the scale of the regulated activities in proportion to the other professional services provided. This is by the whole firm. Whether and to what extent the activities that are regulated activities are held out by you as separate services. The impression given of how the firm provides regulated activities, for example through its advertising, website, promotional materials. So, again, what proportion of your firm's work is a regulated activity, and where do we draw the line? There's a lot of uncertainty. Is 10% too much? Is 1%? Does it have to be 1%, 5%, 20%, 30%? How about 35%? And again, nobody really can answer that question. The complementary test is entirely different, and this is the one that you're going to struggle to achieve. The incidental test, most people watching this video will probably be able to satisfy that, but just bear in mind this complementary test as well. It contrasts very sharply with the incidental test. It requires regulated activities to arise out of or be complementary to the provision of particular professional services to particular clients. Remember, going right back to one of the early slides, section 332, I'm going to read it out. Rules made by the SRA must be designed to secure that in providing a particular professional service to a particular client, the member carries on only regulated activities which arise out of or are complementary to the provision by him of that service to that client. So this is not the firm as a whole. It doesn't matter. If you only have one client for whom you carry out some consumer credit activity, 1 out of 10,000 clients, you'll pass the incidental test. But if for that one client you only do regulated activity, then you will not pass the complementary test. Satisfying the test necessitates an assessment of the services provided on a case-by-case basis, client-by-client basis, rather than by the firm overall. So if 10% of the work you do for one client is consumer credit work, is that complementary? Again, we don't know, 20%, 40%, 5%. Before I sort of chat to Stephen about some of these issues, I want to talk about the SRA consultation paper which came out yesterday. The consultation seeks views on the SRA's proposal to withdraw from the Financial Conduct Authority's designated professional body regime for the purposes of consumer credit activity. I'll try and put that into lay terms. It means that what the SRA wants is for the exempt professional firm regime, which I've already explained, not to be available at all in relation to consumer credit activity. They want to scrap that entire regime in relation to consumer credit activity, and any firms who undertake or carry out any consumer credit activity must therefore obtain full Financial Conduct Authority authorization. So it means that SRA authorised firms carrying on any regulated credit activity would need to apply to the FCA for authorisation rather than being able to rely on the exempt professional firm regime. What does this mean? It means that if the SRA gets its way, and if this is what is ultimately decided, then we have the ultimate regulatory nightmare of dual regulation, of your firm being regulated both by the Solicitors Regulation Authority and the Financial Conduct Authority at the same time. We've seen something of a turf war between the Financial Conduct Authority and the SRA. Just to recap, as a consequence of the transfer of this regulation from the OFT to the FCA, it's the SRA who is now required to have in place regulatory arrangements governing how SRA authorised firms carry out the consumer credit activities. But it's not the SRA who get to decide what those arrangements are. The arrangements have to be approved by the Financial Conduct Authority. So the SRA has to put its proposals together, take them to the FCA and say, this is how we'd like to do it. And the FCA can say yes or no. And in fact, the SRA have done that, and the FCA have said no. Why? Both regulatory bodies have their own regulatory ideology, their own set of beliefs about how to effectively regulate. The Solicitors Regulation Authority prefers, as we know, this model of outcomes-focused and principle-based regulation. The Financial Conduct Authority prefers a much more detailed, prescriptive and rules-based system. It's rather ironic because it was the Financial Conduct Authority's predecessor, the FSA, who invented the whole principle-based model of regulation, which the SRA then copied. But because of the financial collapse and the criticism the FSA received, the Financial Conduct Authority has gone back to a very prescriptive model of regulation, very detailed. So we have here a disagreement between two regulatory bodies. We have the SRA saying we would like to do this in a consistent way with our approach to regulation, which is principle-based, it's outcomes-focused, we want it to sit nicely with the rest of the SRA handbook. And then we have the Financial Conduct Authority saying, I'm sorry, that is not good enough. You know, our regulated community is subject to extremely detailed prescriptive rules set out in Conc and elsewhere, and we want you to put those provisions of Conc into the way in which you're going to regulate the solicitors. So the SRA's response to that instruction from the Financial Conduct Authority is, if I was being critical, I would say they've taken their bat and ball home. And they've said, right, well, if that's the case, we don't want to be involved. And we don't want to regulate solicitors in accordance with a regulatory model which we do not believe in and do not use. So the SRA's proposal in this consultation paper is to withdraw from the exempt professional firm regime altogether in relation to consumer credit activity, effectively meaning that that regime ceases to be available for consumer credit activity. So there's been this regulatory fight going on about which model ought to be used. The Financial Conduct Authority has won the fight, and the SRA has said, right, well, in that case, we don't want to be involved anymore. We want to duck out. And that, if the SRA gets its way, it's quite simple. It means if you want to do any consumer credit activity, you have to be fully authorised by the Financial Conduct Authority. You have to become dual regulated. So do all firms really need that then? How many firms will have to go for full FCA authorisation if the SRA gets its way? Well, we can start by saying that about 10% of the firms out there have substantial debt collection departments, and they'll be the first ones who will have to go for FCA authorisation, about 1,100 firms. The SRA's estimate is that by the time you take into all the other definitions of things which might fall within the definition of consumer credit activities, we're going to be looking at about 7,500 firms, something in the region of 65% of all law firms, perhaps higher. And why? Well, the types of things that are caught: credit broking, where a client's referred to a lender for a loan that's to be a credit agreement, or where a client's referred for a hire purchase loan. Any debt-related consumer credit activities, which include debt adjusting, which is negotiating terms with creditors on behalf of a client for settlement of the debt due under a specified regulated credit or consumer hire agreement. Debt counselling, providing any advice to a client about the liquidation of a debt due under a specified regulated credit or consumer hire agreement. Debt collecting, any steps associated with the collection of debts due to others. Entering into a regulated credit agreement as a lender, so agreeing with an individual client that professional fees are paid by instalments. I'll say that again: if you agree with the client that your professional fees can be paid by instalments, you will be caught. There's a slight exception to that if you take fewer than 4 payments. If you take them over a period of less than 12 months, and if you don't charge any interest, that will be exempt. But if you say to a client, okay, pay me back over 6 months, you're caught. Providing credit information services, so on behalf of your client seeking to amend information held by a credit information agency, or anything like that, or holding or disclosing any sort of information. In our estimation, I strongly believe that something close to 100% of law firms do carry out consumer credit activity of one kind or another. And even, if you take the example of a niche personal injury practice who carry out nothing but other than straightforward RTA claims all of the clients are on a CFA, you know, you may be sitting there thinking, well, this has nothing to do with me. But in my view, it may well become something to do with you. You know, for example, if one of your clients breaches the terms of the CFA and becomes liable to pay their own costs, and you have to go after that client for your costs, well, as soon as you say, you may have £5,000 worth of costs. As soon as you start to say to that client, okay, well, you can pay us back over a period of time, you'll be committing a criminal offence. So unless that client can give you the £5,000 straight away, you know, forget about chasing it and forget about trying to get it back from the client. So, you know, when you think through the scenarios that are likely to arise over the period of the next 5 years or so, I don't think there'll be a law firm in the country who won't carry out some consumer credit activity. And time will tell whether I'm correct about that or not. On your screen now, there should be something called the Financial Conduct Authority's Jargon Buster. I've highlighted this document because it contains a very helpful summary of which activities fall within the scope of consumer credit activity. It's written in pretty straightforward terms. So have a look at that if you're not sure whether this affects you or not. Again, the SRA has rightly identified that this complementary test required for the EPF, the reason why the SRA want to bow out of the EPF system is that they've identified that the complementary test is going to be extremely difficult for firms to meet, ever. Bear in mind, the old Law Society group licence simply required the consumer credit activity to be carried out in the course of practice. That's all it required. The complementary test, as we've seen, requires the consumer credit activity to arise out of or be complementary to the provision of a particular professional service to a particular client. This means that it's no longer possible for SRA authorised firms to carry on a consumer credit activity in isolation for a client, at least not under the EPF regime. So here we are. The Financial Conduct Authorities instructed the SRA to incorporate large parts of CONC into its rules. The SRA doesn't believe that CONC is compatible with OFR, and the SRA believes that to change itself and to prepare itself to regulate in the Financial Conduct Authority's style would be too expensive, burdensome, difficult, complicated, challenging, etc., and they don't want to do it. So what if you decide to become authorised? Well, here's perhaps the killer blow. If you decide to become authorised, you will no longer be able to use the EPF regime for any other work that you do. For example, issuing title indemnity insurance policies, ATE policies, etc. You cannot be Financial Conduct Authority authorised and exempt at the same time. So all of your work, all of your financial services work, will have to be fully regulated by the Financial Conduct Authority. So you will not only have to comply with CONC in relation to consumer credit, you'll have to comply with CONC's equivalent in relation to insurance mediation, investment, anything, any financial services activity that you carry out. So effectively you become a full financial services business. If there is any, effectively what that means in my view is the end of the EPF regime in full. The EPF regime cannot survive this if the SRA gets its way. If there is a commercial opportunity in all of this, the fact that you may have to become a Financial Conduct Authority authorised business means that, like any other business, you can start to make money out of that activity. And the old idea of you not making money out of it will disappear. So there may be opportunities to develop new income streams from your financial services activity. So I hope that's a helpful sort of introduction. Please do get in touch with us.
Controversial stuff there, Chris. Okay, well, thank you for joining us today. We hope it's proved useful for you. And if you would like, next week we're going to actually hold a panel, which if you would like to join us on this panel, which we're going to record here at our studio in Manchester, then you're welcome to contact us, get in touch to discuss the practical implications of these changes. So contact us at LBS Legal, either phone us or email us, and we'd love to have you join us at the panel for next week's discussion in relation to these issues that Chris has discussed today. We appreciate obviously that the subject itself is a very dry subject, so if you've made it this far through the presentation, well done, but it is a very serious subject and we feel that we have a duty to you to make sure that you're well informed. So thank you again for your patience, thank you for joining us, and we'll look forward to seeing you next time. Take care, bye.